Enemy may apply for letters patent. Section 10. That nothing contained in this act shall be held to make unlawful any of the following acts. A. An enemy or ally of an enemy may file and prosecute in the United States an application for letters patent or for registration or of trademark, print, label, or copyright, and may pay any fee therefore in accordance with and as required by the provisions of existing law, and fees for attorneys or agents for filing and prosecuting such application. Any such enemy or ally of an enemy who is unable during war or within 6 months thereafter, on account of conditions arising out of a war, to file any such application or to pay any official fee or to take any action required by law within the period prescribed by law may be granted an extension of 9 months beyond the expiration of said period, provided the nation of which the said applicant is a citizen, subject, or corporation shall extend substantially similar privileges to citizens and corporations of the United States. U.S. citizens may apply. Let me slide this over just a scooch here. May apply in enemy country. B. Any citizen of the United States or any corporation organized within the United States may, when duly authorized by the President, pay to any enemy or ally of the enemy any tax, annuity, or fee which may be required by the laws of such enemy or ally of the enemy nation in relation to patents and trademarks, prints, labels, and copyrights, and any such citizen or corporation may file and prosecute an application for letters patent or for registration of trademarks, print, label, or copyright in the country of an enemy or ally of an enemy after first submitting such application to the President and receiving license so to file and prosecute and to pay the fees required by law and customary agents' fees, the maximum amount of which in each case shall be subject to the control of the President. U.S. citizens may obtain license to use enemy patent. C. Any citizen of the United States or any corporation organization within the United States desiring to manufacture or cause to be manufactured a machine, manufacture, composition of matter or design, or to carry on or cause to be carried on a process under any patent or to use any trademark, print, label, or copyrighted matter or design, or to carry on or cause to be carried on a process under any patent or to use any trademark, print, label, or copyrighted matter owned or controlled by an enemy or ally of an enemy at any time during the existence of a state of war may apply to the President for a license, and the President is hereby authorized to grant such a license non-exclusive or exclusive as he shall deem best, provided he shall be of the opinion that such grant is for the public welfare and that the applicant is able and intends in good faith to manufacture or cause to be manufactured the machine, manufacture, composition of matter or design, or to carry on or cause to be carried on the process or to use the trademark, print, label, or copyright matter. The President may prescribe the condition of the license, including the fixing of price of articles and products necessary to the health of the military and naval forces of the United States or the successful prosecution of the war, and the rules and regulations under which such license may be granted, and and the fee which shall be charged therefor, not exceeding $100 and not exceeding 1% of the fund deposited as hereinafter provided. Such license shall be a complete defense to any suit at law or in equity instituted by the enemy or ally of the enemy owners of the letters patent, trademark, print, label, or copyright, or otherwise against the licensee for infringement or for damages, royalty, or other money award on account of anything done by the licensee under such license, except as provided in subsection F hereof. D. Statement of use and enjoyment of patent. D. The licensee shall file with the President a full statement of of the extent of the use and enjoyment of the license, and of the price received in such form and at such stated periods, at least annually, as the President may prescribe, and the licensee shall pay at such time as may be required to the alien property custodian not to exceed 5% of the gross sum received by the licensee from the sale of said invention or use of the trademark, print, label, or copyrighted matter, or if the President shall so order, 5% of the value of the use of such invention, trademark, print, labels, or copyrighted matter to the licensee as established by the President, and sums so paid shall be deposited by said alien property custodian forthwith in the Treasury of the United States as a trust fund for said licensee and for the owner of the said patent, trademark, print, label, or copyrighted registration as hereafter provided, to be paid from the Treasury upon order of the court as provided in subdivision F of this section, or upon the discretion of the alien property custodian. Term of license. E. Unless surrendered or terminated as provided in this act, any license granted hereunder shall continue during the term fixed in the license, or in the absence of any such limitation during the term of the patent, trademark, print, label, or copyrighted registration under which it is granted. Upon violation by the licensee of any of the provisions of this act or of the conditions of the license, the President may, after due notice and hearing, cancel any license granted by him. Enemy owner may sue for accounting. F. The owner of any patent, trademark, print, label, or copyright under which the license is granted hereunder may, after the end of the war and until the expiration of the 1 year thereafter, file a bill in equity against the licensee in the District Court of the United States for the district in which the said licensee resides, or if a corporation in which it has its principal place of business, to which suit the Treasurer of the United States shall be made a party for recovery for the said licensee for all use and enjoyment of the said patented invention, trademark, print, label, or copyrighted matter, provided, however, that whenever suit is brought, as above, notice shall be filed with the alien property custodian within 30 days after date of entry of suit. All defenses available, provided further that the licensee may make any and all defenses which would be available where no license granted. The court on due proceedings may adjudge and decree to the said owner payment of a reasonable royalty. The amount of said judgment and decree, when final, shall be paid on order of the court to the owner of the patent from the fund deposited by the licensee, so far as such deposit will satisfy said judgment and decree, and the said payment shall be in full or partial satisfaction of the said judgment and decree as the facts may appear, and if after payment of all such judgments and decrees there shall remain any balance of said deposit, such balance shall be repaid to the licensee on order of the alien property custodian. If no suit is brought within 1 year after the end of the war, or no notice is filed as above required, then the licensee shall not be liable to make any further deposits, and all funds deposited by him shall be repaid to him on order of the alien property custodian upon entry of suit and notice filed as above required, or upon repayment of funds as above provided. The liability of the licensee to make further reports to the President shall cease. Practice of hearing. If suit is brought as above provided, the court may at any time terminate the license and may in such event issue an injunction to restrain the licensee from infringement thereafter, or the court, in case the licensee prior to suit shall have made investment of capital based on possession of the license, may continue the license for such period and upon such terms and with such royalties as it shall find to be just and reasonable. Enemy may enjoy infringement of patent. G. Any enemy or ally of the enemy may institute and prosecute suits in equity against any person other than a licensee under this act to enjoy infringement of letters, patent, trademark, print, label, and copyright in the United States owned or controlled by said enemy or ally of the enemy in the same manner and to the extent that that he would be entitled so to do if the United States was not at war, provided that no financial judgment or decree shall be entered in favor of such enemy or ally of the enemy by any court except after 30 days' notice to the alien property custodian. Such notice shall be in writing and shall be served in the same manner as civil process of federal courts. Powers of attorney valid. H. All powers of attorney heretofore and hereafter granted by the enemy or ally of the enemy to any person within the United States, insofar as they shall be valid. Patents on inventions of determinable detrimental consequences may be withheld. I. When the publication of the invention by the granting of a patent may, in the opinion of the president, be detrimental to the public safety or defense, or may assist the enemy or endanger the successful prosecution of the war, he may order that the invention be kept secret and withhold the grant of a patent until the end of the war, provided that the invention disclosed in the application for said patent may be held abandoned upon being established before or by the commissioner of patents that in violation of said order, said invention has been published, or that an application for a patent therefore has been filed in any other country by the inventor or his assigns or legal representatives without the consent or approval of the commissioner or under a license of the president. When an applicant whose patent is withheld as herein provided and who faithfully obeys the order of the president above referred to shall tender his invention to the government of the United States for its use, he shall, if he ultimately receives a patent, have the right to sue for compensation in the court of claims, such right to compensation to begin from the date of the use of the invention by the government, may prohibit imports. Section 11. Whenever during the present war the president shall find that the public safety so requires and shall make proclamation thereof, it shall be unlawful to import into the United States from any country named in such proclamation any articles or articles mentioned in such proclamation, except as such time or times and under such regulations or orders, and subject to such limitations and exceptions as the president shall prescribe, until otherwise ordered by the president or by Congress, provided, however, that no performance shall be given to the ports of one state over those of another. Investment of funds in government bonds. Subsection 12. Section 12. That all monies, including checks and drafts, payable on demand, paid to or received by the alien property custodian pursuant to this act shall be deposited forthwith into the Treasury of the United States and may be invested and reinvested by the Secretary of the Treasury in the United States bonds or United States certificates of indebtedness under such rules and regulations as the President shall prescribe for such deposit investments and sale of securities, and as soon after the end of the war as the president shall deem practicable, such securities shall be sold and the proceeds deposited into the Treasury. Banks may act as depositories for custodian, also Secretary of Treasury. All other property of the enemy or ally of the enemy conveyed, transferred, assigned, delivered, or paid to the alien property custodian hereunder shall be safely held and administered by him, except as hereinafter provided, and the president is authorized to designate as a depository or depositories of property of an enemy or ally of an enemy any bank or banks or trust company or trust companies or other suitable depository or depositories located and doing business in the United States. The alien property custodian may deposit with such designated depository or depositories, or with the Secretary of the Treasury, any stocks, bonds, notes, time drafts, time bills of exchange, or other securities or property except money or checks or drafts payable on demand, which are required to be deposited with the Secretary of the Treasury, and such depository or depositories shall be authorized and empowered to collect any dividends or interest or income that may become due and any maturing obligation held for the account of such custodian. Any monies collected on said account shall be paid and deposited forthwith by said depository or by the alien property custodian in the Treasury of the United States as hereinbefore provided. Bonds necessary. The President shall require all such designated depositories to execute and file bonds sufficient in his judgment to protect property on deposit, such bonds to be conditioned as he may direct. Power of alien property custodian. The alien property custodian shall be vested with all of the powers of the common law trustee in respect of all property other than money which has been or shall be or which has been or shall be required to be conveyed, transferred, assigned, delivered, or paid over to him in pursuance of the provisions of this act, and in addition thereto, acting under the supervision and direction of the President, and under such rules and regulations as the President shall prescribe, shall have power to manage such property and do any act or thing in respect thereof, or make any disposition thereof, or of any part thereof by sale or otherwise, and exercise any rights or powers which may be or become appertent thereto, or to the ownership thereof in like manner as though he were the to the ownership thereof in like manner as though he were the absolute owner thereof, provided that any property sold under this act, except when sold to the United States, shall be sold only to American citizens at public sale to the highest bidder after public advertisement of time and place of sale, which shall be where the property or a major portion thereof is situated, unless the President stating the reasons therefor in the public interest shall otherwise determined. Provided further that when sold at the public sale, the alien property custodian, upon the order of the President stating the reasons therefor, shall have the right to reject all bids and resell such property at public sale or otherwise as the President may direct. Any person purchasing property from the alien property custodian for an undisclosed principal or for resale to a person not a citizen of the United States or for the benefit of a person not a citizen of the United States shall be guilty of a misdemeanor and upon conviction shall be subject to the fine of not more than $10,000 or imprisonment for not more than 10 years or both, and the property shall be forfeited to the United States. It shall be the duty of every corporation incorporated within the United States and every unincorporated association or company or trustee or trustees within the United States issuing shares or certificates representing beneficial interest to transfer such shares or certificates upon his or their books into the name of the alien property custodian upon demand, accompanied by the presentation of the certificates which represent such shares or beneficial interest. The alien property custodian shall forthwith deposit in the Treasury of the United States, as hereinbefore provided, the proceeds of any such property or rights so sold by him. Delivery to the United States Treasury. Any money or property required or authorized by the provisions of this act to be paid, conveyed, transferred, assigned, or delivered to the alien property custodian shall, if said custodian shall so direct, by written order, be paid, conveyed, transferred, assigned, or delivered to the Treasury of the United States with the same effect as if to the alien property custodian. Distribution of alien property held by custodian. After the end of the war, any claim of any enemy or of any ally of the enemy to any money or other property received and held by the alien property custodian or deposited in the United States Treasury shall be settled as Congress shall direct, provided, however, that on order of the President as set forth in the Section 9 hereof, or of the court as set forth in Section 9 and 10 hereof, the alien property custodian or the Treasurer of the United States, as the case may be, shall forthwith convey, transfer, assign, and pay to the person to whom the President shall so order, or in whose behalf the court shall enter final judgment or decree, any property of an enemy or ally of an enemy held by said custodian or by said treasurer so far as may be necessary to comply with said order of the president or said final judgment or decree of the court, and provided further that the treasurer of the United States, on order of the alien property custodian, shall, as provided in sections 10 hereof, repay to the licensee any funds deposited by said licensee. Shipmaster's certificate as cargo and consignee. Section 13, that during the present war, in addition to the facts required by Section 4100 and 1997, 4198, and 4200 of the revised statute as amended by the Act of June 15, 1917, to be set out in the master's and shipper's manifest before clearance will be issued to vessels bound to foreign ports. The master or person in charge of any vessel before departure of such vessel from port shall deliver to the collector of customs of the district wherein such vessel is located a statement duly verified by oath that the cargo is not shipped or to be delivered in violation of this act, and the owners, shippers, or consignors of the cargo of such vessel shall in like manner deliver to the collector like statement under oath as to the cargo or the parts thereof laden or shipped by them, respectively, which statement shall contain also the names and addresses of the actual consignees of the cargo, or if the shipment is made to a bank or other broker, factor, or agent, the names and addresses of the person who are the actual consignees on whose account the shipment is made. The master or person in control of the vessel shall, on reaching port of destination of any of the cargo, deliver a copy of the manifest and of the said master's, owners, shippers, or consignors statement to the American Counselor's Office of the district in which the cargo is unladen. Collector may refuse clearance for false representation. 14. Section 14, that during the present war, whenever there is reasonable cause to believe that the manifest or the additional statements under oath required by the preceding section are false, or that any vessel, domestic or foreign, is about to carry out of the United States any property to or for the account or benefit of an enemy or ally of an enemy, or any property or person whose exports, taking out, or export will be in violation of this act, the collector of the customs for the district in which such vessel is located is hereby authorized and empowered, subject to review by the president, to refuse clearance to any such vessel, domestic or foreign, for which clearance is required by law, and by formal notice served upon the owner's master or person or persons in command or charge of any domestic vessel for which clearance is not required by law, to forbid the departure of such vessel from the port, and it shall thereupon be unlawful for such vessel to depart. The collector of customs shall, during the present war, in each case report to the president the amount of gold or silver coin or bullion or other money of the United States contained in any cargo intended for export. Such report shall include the names and addresses of the consignor and consignees, together with any facts known to the collector with reference to such shipment, and particularity those which may indicate that such gold or silver coin or bullion or monies of the United States may be intended for delivery or may be delivered directly or indirectly to an enemy or ally of an enemy. Appropriation 450,000. Section 15, that the sum of the 450,000 is hereby appropriated out of any money in the Treasury of the United States not otherwise appropriated, to be used in the discretion of the President for the purpose of carrying out the provisions of this act during the fiscal year ending June 13, 1918, and for the payment of salaries of all persons employed under this act, together with the necessary expenses for transportation, substances, rental of quarters in the District of Columbia, books of reference, periodicals, stationery, typewriters, and exchange thereof, miscellaneous supplies, printing to be done at the government printing office, and all other necessary expenses not included in the foregoing. Penalty for violation. Subsection 16. Section 16, that whoever shall willfully violate any of the provisions of this act or of any license, rule, or regulation issued thereunder, and whoever shall willfully violate, neglect, or refuse to comply with any order of the President issued in compliance with the provision of this act shall, upon conviction, be fined not more than $10,000, or if a natural person imprisoned not more than 10 years, or both, and the officer, director, or agent of any corporation who knowingly participates in such violation shall be punished by a like fine, imprisonment, or both, and any property, funds, securities, paper, or other articles or documents, or any vessel together with her tackle, apparel, furniture, and equipment concerned in such violation shall be forfeited to the United States. United States District Courts, subsection section 17. That the district courts of the United States are hereby given jurisdiction to make and enter all such rules as to notice and otherwise, and all such orders and decrees, and to issue such processes as may be necessary and proper in the premise to enforce the provisions of this act, with a right of appeal from a final order or decree of such court as provided in section 128 and 238 of the Act of March 3rd, 1911, entitled An Act to Codify, Revise, and Amend the Laws Relating to the Judiciary. Philippines and Canal Zone. 18. Section 18. That the several courts of the first instance in the Philippines Islands and the District Court of the Canal Zone shall have jurisdiction of offenses under this act committed within their respective districts, and concurrent jurisdiction with the district courts of the United States of offenses under this act committed upon the high seas, and of conspiracies to commit such offenses as defined by section 37 of the act entitled An Act to Codify, Revise, and Amend the Penal Laws of the United States, approved March 4th, 1909, and the provisions of such section for the purpose of this act are hereby extended to the Philippine Islands and to the Canal Zones. Publication in foreign language. 19. Section 19. That 10 days after the approval of this act and until the end of the war, it shall be unlawful for any person, firm, corporation, or association to print, publish, or circulate, or cause to be print, published, or circulated in any foreign language any news item, editorial, or other printed matter respecting the government of the United States or of any nation engaged in the present war, its policies, international relations, the state, or conduct of the war, or any matter relating thereto, provided that this section shall not apply to any print, newspaper, or publication where the publisher or distributor thereof, on or before offering the same for mailing or in any manner distributing it to the public, has filed with the postmaster at the place of publication in the form of an affidavit a true and complete translation of the entire article containing such matter proposed to be published in such print, newspaper, or publication, and as caused to be printed in plain type in the English language at the head of each such item, editorial, or other matter, on each copy of such print, newspaper, or publication, the words true translation filed with the postmaster at blank on, naming the post office where the translation was filed and the date of the filing thereof, as required by the act of, here giving the date of this act. Any print, newspaper, or publication in any foreign language which does not conform to the provisions of this section is hereby declared to be non-mailable, and it shall be unlawful for any person, firm, corporation, or association to transport, carry, or otherwise publish or distribute the same, or to transport, carry, or otherwise publish or distribute any matter which is made non-mailable by the provisions of the Act relating to espionage, approved June 15, 1917, provided further that upon the evidence satisfactory to him that any print, newspaper, or publication printed in a foreign language may be printed, published, and distributed free from the foregoing restrictions and conditions without without detriment to the United States in the conduct of the present war. The President may cause to be issued to the printers or publishers of such print newspaper or publication a permit to print, publish, or circulate the issue or issues of their print newspaper or publication free from such restrictions and requirements. Such permit to be subject to the revocation at his discretion, and the Postmaster General shall cause copies of all such permits and revocations of permits to be furnished to the Postmaster of the Post Office serving the place from which the print, newspaper, or publication granted the permit is to emanate. All matter printed, published, and distributed under permit shall bear at the head thereof, in plain type in English language, the words published and distributed under permit authorized by the act of, here giving the date of this act, on file at the post office of, giving the name of office. Any person who shall make an affidavit containing any false statements in connection with the translation provided for in this section shall be guilty of a crime of perjury and subject to the punishment provided thereof by sections 125 of the Act, March 4th, 1909, entitled An Act to Codify, Revise, and Amend the Penal Law of the United States, and any person, firm, corporation, or association violating any other requirements of this section shall, on conviction thereof, be punished by a fine not more than 500, or by imprisonment not more than 1 year, or in the discretion of the court may be both fined and imprisoned. Guarantee Trust Company of New York functions and facility. Guarantee Trust Company of New York invites accounts of banks and bankers, firms, corporations, and individuals. Functions and facilities. General Banking Department transacts the banking business of the company, extends credit, pay interest on daily balances and on certificates of deposit. Department of Bank and Banks centralizes the company's various facilities for the advancement of its correspondence interest and promotes the efficient handling of their business. Foreign Department undertakes all kinds of foreign banking transactions, has direct relations with leading banks in all parts of the world, accepts drafts for the purpose of financing shipments to or from the United States, issues letters of credit and travelers checks, deals in acceptances. Bond Department investigates, examines, and underwrites bond issues, giving information to customers regarding their investments, buys and sells securities. Trust Department acts as trustee under corporate mortgages, acts as executor, administrator with the will annexed, testamentary trustee, guardian of estates of infants, committee of property of incompetence, trustee under voluntary trust, acts as depository and agent of voting trustees, holding securities or cash under escrow agreements, acts as custodian of securities and financial agents for individuals and corporations, acts as depository for corporations organizing, reorganizing, or establishing, transfer, registration, and coupon department, acts as transfer, physical, and dispersing agent, registrar, and co-registrar. Publicity Department prepares for the benefit of the customer and other digests of state and federal laws relating to taxation, governmental requirements, etc., issuing pamphlets on financial and economic subject of timely interest, and furnishing information on business questions. Statistical Department organized to furnish accurate and up-to-date information in regard to securities and investment conditions. Credit Department furnishes information in regard to the financial responsibility of individuals and business houses throughout the world. Member Federal Reserve System. Through our membership in the Federal Reserve System, we are enabled to give our customers the benefit of its credit facilities and rediscount and collection privileges. Foreign offices. This company maintains fully equipped offices in London and Paris. It has resident representatives and travelers in many countries abroad, affording to importers and exporters complete facilities for extending their international trade. Full details of the facilities offered by any or all of the departments will be sent on request. So you got to request those if you want to, if you're interested in anything the Guarantee Trust Company of New York has to offer, which is really interesting. When you get to the trust department, I would be highly intrigued about what they offer with the trust department. All right. And that concludes this book, ladies and gentlemen. Uh, I hope that helps you out in understanding the Trading with the Enemy Act and why I feel that it's important to get familiar with it. And again, let's see. Let's go all the way to the top here. And they got a place where you can write. Oh, yes, let's back out of this just a hair so you can see all this. So you understand what it all is. You can pause the screen and you can read all that. I'm not going to make this video any longer than it needs to be. All right. Now, what I was looking for was an address, and I think it is right there. There's your address for all right, there you guys go. Next time we come back, we'll be talking about Title 15. I'm going to be showing you the same shit in Title 50. I'm going to be showing you the same stuff in Title 50. It's got a little more detail in it. I hope this helps you guys out. Thanks again for all your support, and we'll talk to you soon.